glad you're here. I'm glad we're able to do this. We have these wonderful heaters, and we can talk about the new laws, new forms, new cases, and hopefully get you up to speed with some things going on. It won't be everything. There's a lot going on this year, like every year. I actually think that this year is not as impactful, as crazy, perhaps, as other years. We'll kind of work through some of these things, but we've been through a roller coaster, and maybe we're kind of on a little flat area here for 2025. Unless you're a landlord, and if you are, I'm sorry, in California, you're in for more roller coaster to come for sure. I'm an attorney. I am not your attorney. I just say that because everything I'm telling you is informational. Please consult with your attorney as to your specific situation and your specific facts and circumstances before you make any decisions. We're always happy to talk with you. We offer a 15-minute complimentary consultation on our website that you can schedule there if you have any questions, or your clients as well can schedule it through there. So feel free to go to that. We'll have our website up at the end. So just a little bit about me. Maybe one of the reasons I hopefully can speak not as much like an attorney, but can speak to each one of you as real estate professionals is I got involved in real estate in high school. Started dating a girl whose family was all involved in real estate. My dad was an attorney. I ended up marrying that girl, so I married into a real estate family. I also married into a USC family. But I married that girl. And so I married into a real estate family, but I also decided to combine it with what came from my side, which was my dad. And so I became a real estate attorney. And as you might guess, real estate law school is expensive. And so what do you do to earn money during that time period? Well, you get a job. And I decided to go get my broker's license. So in law school, I got my broker's license. I went through the same classes you guys did, took the same test. And I've had my broker's license for about 20 years now as well. So I've followed along with this. I've been in the trenches with you, and hopefully we can have this make sense to all of us as we work through these various things. So 2025, new year, new forms, new laws, and new cases. And we'll go through it in that order. So let's start with our new and our revised forms. There's not a huge, like I said, a huge change in the forms this year, but we're going to be talking about those mainstays, those main forms that you use. So we're going to be talking listing agreement, buyer-broker agreement, the residential purchase agreement, the counteroffers, the SPQ, and what was the one that I missed? The cancellation of the buyer representation agreement, which is new and comes about as a result of the buyer-broker agreement. So let's start with the one that we are all using now. I hope all of us are using the buyer representation agreement. Otherwise, you're going to have some trouble. As you might know, the buyer representation agreement is mandated by industry changes and law, industry changes and statute, with a 3-month maximum, mandated by the industry changes. So, as you know, nobody works for free. If you represent a buyer, you want to get paid, right? And it was not very common before to have a buyer representation agreement. I would guess most of you probably did not use a buyer representation agreement, and now we are all using a buyer representation agreement if we want to get paid. So the BRBC, become familiar with this form when you're working with your buyers. This answers the question, how are you going to get paid? Well, you are going to get paid first and foremost. You think of it, you're going to get paid by the buyer. The buyer agrees to pay you X percent, usually X percent, or you could set a specific dollar amount, but of the final purchase price. Standard, we know how to do that. But there's this new box in the buyer representation agreement where what if the buyer does not have independent sufficient funds to pay you? What do you do? Now, we all know that a lot of times buyers are stretching themselves. They are stretching their budgets. They are going to the max of what they can afford. And so a lot of times they do not have available for them independent funds to be able to pay you as a broker upon a successful closing. So section, and I don't know if we can read this outside, but you can look at this later as well on your forms. Section G of the BRBC, sub 2, is where a buyer can check the box that says buyer does not have sufficient funds to pay the broker. And there's a little section here, buyer broker's obligation to represent the buyer in a transaction is contingent upon a seller's agreement to pay the amount of compensation in paragraph 2E1. So the buyer, by checking this box, is representing to you, the broker or agent, that they do not have sufficient funds with which to pay you upon the closing, and that they will ask the seller to pay for your broker fees, for your compensation. And this is a contingency built into the RPA and into the BRBC. So how does the buyer compensate the broker if there are insufficient funds to pay the broker? Well, you scroll down to the section that's referenced from section 2G2 down here to where it references if the box is checked in 2G2, then the buyer agrees in the RPA, in the offer, to ask for compensation. Pretty obvious. The buyer wants to ask for compensation for the broker from the seller. Yes, check that. Yes, check that box and make that request. But if the agreement is contingent upon the seller or others or both agreeing to pay the broker the full amount that the buyer is contractually obligated to pay the broker, this is a contingency in favor of the broker, and the broker may elect to cancel this agreement related to representation on that specific property if the seller does not agree to pay the full amount that buyer is contractually obligated to pay broker. Broker shall inform the buyer and the other parties that they are proceeding without representation and have a new agency confirmation. So let's say your buyer makes an offer. The BRBC that you have with your buyer says that buyer will pay you 3%. Again, I'm just choosing numbers here. That's not a set industry number. Please don't quote me on this. I'm just using numbers. Okay, 3%. Okay. And the seller says, no way, no how. I read in the news that I don't have to pay anyone anything, so I'm not paying the buyer's broker more than $500. My offer is $500. The buyer goes back to you and says, I told you when we started this thing, I don't have sufficient funds to pay you. I'm sorry you did all this work. I'm sorry that you got this offer out there. I'm sorry that I love this property and I think I'm going to get into escrow, and the seller's only offering $500. What do you do as the buyer's broker? Well, as long as that box is checked, as long as you don't want to work for $500, maybe you do, I don't know, but as long as you don't want to do that, you have an option here to cancel with regard to that specific property, to cancel and to have your contingency to not represent the buyer in that specific property. There should be no surprise to you here, though, as the broker, because that box was checked in the beginning, right? The buyer told you in the beginning, I don't have enough money to pay you. If the seller won't pay you, sorry, out of luck. This is the new world we're living in. There's no automatic payment to you. There's nothing automatically, as you know, offered through the MLS, enforced by the MLS. So this is, you need to be aware of, if that box is checked, you may get almost to escrow, and then you have to decide how much am I willing to work for in this transaction. The BRBC also has a default of non-exclusive in it, non-exclusive. And what that means is that you, as the buyer's broker, buyer's agent, you would only be compensated for properties that you showed to that buyer. So if the buyer finds another property that you have not showed to them, you would not be compensated for that in the non-exclusive way. Also, that buyer in some ways could be working with other agents, and if it's non-exclusive. This is a non-exclusive relationship. What do you do about that? Well, if your buyer is willing to have an exclusive relationship with you, an exclusive relationship, you'll check the box here in section A2 to have an exclusive relationship. And then you'll scroll down to paragraph 15 of the BRBC, which explains a little further this exclusive relationship that you have. And the buyer will initial in this section confirming that they do indeed understand the exclusive nature of this relationship. The exclusive relationship in the BRBC also has a default cancellation potential of 30 days. 30 days, and then the cancellation is effective. So if you have one of these exclusives, you have a default of 30 days to cancel it, and you can reduce that based upon the space that's put in here for changing the number of days on that cancellation. The non-exclusive, again, the default relationship can be canceled by either side at any time.
Let's say that we are in a situation that the seller is not paying and we want to cancel. What form do we use to cancel that?
Funny you should ask. Here we go. The cancellation of buyer representation form right here. This is the next one in order. You read my mind. My agent stinks. That agent is better. What is the effective date of the cancellation upon receipt or a set period of time? Again, the default with the non-exclusive is that the cancellation is effective upon receipt. If it is the scenario with the seller is offering $500 and you, buyer, broker, are exercising your contingency, it would be effective upon receipt of that. You would be exercising your right to withdraw from that particular transaction. Also, what is the scope of the cancellation? Again, any properties that you have shown will have the potential for compensation in there. I say potential because there's a period of days by which the BRBC is effective even after cancellation. So you can change that so that if within, say, 90 days, your buyer goes out and buys it independently outside of you, that you can still be compensated for that. But the COBR will be the cancellation of buyer representation form that you will use to end the relationship. So we're moving along in a transaction. The buyer has, we have the buyers out there that are searching for their property. We also at the same time have a residential listing agreement. So the RLA has been changed a little bit, as you're aware of all the industry changes. I mean, there needed to be some changes here. So the seller's willingness to consider offers requesting concessions, which was the prior MLSA form, has now been incorporated. I'll get to your question in just a minute. Let me finish this. The MLSA language has now been incorporated into the RLA. In section E2 of the RLA is where the seller and the listing broker will decide whether no amount of possible concession will be stated in marketing, the default, or whether such concession can be stated in the MLS if permitted by that MLS, or whether any marketing outside of the MLS can publicize the seller's willingness to consider concessions. So, CRMLS, you have that drop-down box. Is the seller willing to consider concessions? I would probably say yes. Any seller is willing to consider any concession. It depends on the offer. If you're listing a $2 million property, and the buyer comes in at $3 million, is the seller willing to consider all kinds of concessions? Yes. A seller who's unwilling to consider any concessions might be a problem, to state it mildly, and you might have some issues there. So the seller should consider concessions, and that should be made known in the CRMLS that yes, the seller is willing to consider the concessions. Now, outside of the section here, E2, it's a little hairy right now how you want to do it to make specific offers of concessions in public marketing materials. I would probably encourage folks to refrain from making any set specific concession amounts in writing. Phone calls, oral, verbal conversation is okay as well. Again, confirming you are not binding the seller by anything you're saying. You're just discussing potential numbers here. You're discussing potential concessions that the seller may pay the buyer's broker, and everything must be confirmed in writing in the RPA. You always want to have it confirmed by the RPA. The RLA now includes a new section, Section 10. This was effective as of December 2024 release. Section 10 describes what is a concession. Anyone who's confused what a concession is should refer to Section 10. And this will be important as well that you keep straight what are the various types of seller concessions that we're talking about. So we're going to move on in our theoretical transaction to the RPA, and we're going to look at some of the RPA changes here. In particular, the seller concession section, Section G, the seller payment for buyer expenses and costs. So Section G of the RPA, you have 3 boxes here, and this language has been tweaked and changed. Just about every form change, they're doing something with this language here. So here's the current language as of December 2024. The parties have 3 options for the various types of expenses and costs that can be covered by a seller credit to buyer. So let's look at each one of them. G1 is the seller credit to buyer, and it says right there for closing costs. So if the buyer is requesting an amount specifically for closing costs, that amount would go into G1. G2, the additional seller credit terms, it says does not include buyer broker compensation. So we're not to you guys getting paid yet. We're still talking about what is going to be covered by the seller for the buyer. So these might include things like, if your lender will allow it and not have an issue, perhaps repairs, perhaps a carpet credit, things like that, a flooring credit could go into G2 here, the additional seller credit terms. And then we come to G3, which is how do you, the agents and brokers, get paid. G3 is where the buyer will check the box for the seller payment for buyer's obligation to compensate buyer's broker. So again, before this RPA is written, you must have in place a buyer-broker agreement. If you write this RPA without that in place, you risk jeopardizing any compensation for you as a buyer agent. You need to have it even in place before you show a property. That's a different requirement, but I'm talking about just getting you compensated here. You must have the BRBC or similar form in place before this G3 is completed by your buyer. So G3 seller agrees to pay out of the transaction proceeds X% of the final purchase price, or if applicable, a dollar amount, or if checked, a dollar amount toward the obligation of the buyer to compensate buyer's broker. So you will insert here for your buyers the amount that your buyer is requesting the seller pay to the buyer's broker for compensation. Now note carefully down below here, this paragraph is key, and when I first read it, I was a little dismissive of it. I thought to myself, oh well, nobody's going to read this, it's not really going to matter. And I'll tell you why it matters a lot. I'm going to read it to you and then we'll explain it a little further. Buyer affirmatively represents that at the time this offer is made, buyer has a written agreement with buyer's broker that is valid, covers the property, and provides for compensation of no less than the amount stated above. So there is an affirmative representation here by the buyer to the seller that I, buyer, owe my buyer's broker 3% pursuant to a previously executed BRBC. Now again, when I first read this, I thought to myself, people make representations all the time. What's this really going to matter? Why is this going to hold any weight? This can potentially invalidate the RPA if the buyer is acting fraudulently. So let's give our scenario again. Let's think about this. the buyer and the broker, before showing this property, signed a BRBC whereby the buyer said, I will pay you, broker, 1.5%. 1.5% is all I owe you if we are successful in closing the transaction. So the BRBC says 1.5. But what do when they write up the offer? They say, oh, let's put a little higher number in there. Nobody will know. We don't have to exchange the BRBC anymore. So let's just put 3% in there. Then we can each have a little bit more money here. So they insert 3% in there. They make the affirmative representation to the seller that buyer owes broker pursuant to a BRBC 3%. And they get into the transaction. There's a number of ways I can think of that the BRBC might come out, might be required to be disclosed. The seller might see it perhaps on a settlement statement that comes out. There's a lot of different ways. And this affirmative representation here, or frankly, a incorrect representation here, could be seen, in my mind, as something called fraud in the inducement, or just simple fraud. The seller can claim, you buyer lied to me because you affirmatively represented you had this obligation to your broker, and you did not. So be very careful when filling this out that you are not using any amount other than what is true and correct from your BRBC in this section. RPA, the earlier section, what was that? G1 references 5E. So you go down to 5E. This gives you some further information to explain to your buyers as to how that credit must be disclosed to the buyer's lender, and how there can be a potential the buyer's lender can disallow certain amounts. And then the table up there also references section 18. This is part of what I explained to you. This is a little more legalese here, but the buyer affirmatively represents that the buyer, at the time making this offer, has a written agreement that is valid, covers the property, and provides for compensation for no less than the amount stated in 3G3. Okay. If any representation is not true, then seller has no obligation to pay buyer's broker. Kiss your compensation goodbye if your buyer has lied in the RPA here. The seller has no obligation to pay you, the buyer's broker, if any of those representations are not true. All right, probably scared you enough. Let's take a couple questions and we'll move on.
So,
go ahead.
The previous iteration had an addendum. In that addendum, it said that we could request a copy of the buyer representation agreement. This one does not.
No.
Can we still request that?
Okay, so the question is, the previous version of the RPA had a provision wherein a copy of the BRBC could be requested, or the last page could be requested showing the percentage of the buyer owed to the broker. That has now been removed, but nothing prohibits your seller from requiring, as a condition of accepting this offer, that the seller be provided a copy of the BRBC, of the valid, enforceable, fully signed BRBC. The seller can say, I want that document. I don't accept your affirmative representation as to what the amount is. I want the actual signed document. So yes, that can be made a condition of it. I'll tell you as well, don't try to backdate things. There are things called signing certificates within e-service programs that have specific timestamps, date and timestamps on them. So please don't try to go back and backdate anything. Just get the BRBC signed when you first start showing properties, working with your buyer. One more question.
So if you have the BRBC, and it's put in, I guess we're going to use numbers, 3%.
Mm-hmm.
And you just spell the RPA and you say 3%. And then the counteroffer comes back that says roll and pay 2%. You can still do that deal? You're saying you can still...
Again, hypothetical, no set numbers. Right? Okay. Purely hypothetical. 3% in the BRBC. The buyer goes and makes the offer on their dream home. The seller comes back and says, I'm only willing to pay 2% of the seller's of my money to satisfy the buyer's obligation to the buyer's broker. What is the buyer to do? Well, the buyer still owes, the buyer is still obligated to pay that 3% to the buyer's broker, yes. But can they agree amongst themselves that we will modify this agreement to 2%? Yes. You can modify the agreement according to what is being offered in that transaction. Also, the difference is you are modifying it down, not up. Down is more consumer, pro-consumer. Think about how a lot of these lawsuits have developed. A lot of the sentiment around it is all of real estate's anti-consumer. We're going to pass all these laws and have these judgments because real estate people stink and we need to protect the consumers. Part of what you're doing in this scenario is a pro-consumer thing to protect the sellers as well. You are taking less than you are owed. So I would see it as equally as a good option to do if there's only 2% on the table.
So just like an addendum or something you would fill out.
An addendum that you would fill out, yes. Again, in writing, signed by the parties, but yes, that would be fine. Let's move on. So you're in the transaction, you're moving along, you've submitted your RPA, and the seller's thinking about it. You know there's the default of 3 days, after which the RPA expires. And day 3 comes and goes without a response from the seller. So day 4, the seller wakes up and says, I really like that offer. I want to accept that offer. Well, there's just one problem. Technically, that offer has expired by its terms. Now, usually when we're in a transaction, you like it, you would just send out the counteroffer, you would move on, everyone would act like everything's fine, and you'd get into escrow. That works. That has worked. But we're gonna make this a little more official, maybe a little more along the lines of legal. So I don't mean legal in that way. I mean strictly legal. Let's put it that way. We're going to do this strictly legally, okay? So what do you do with a late acceptance or a late counteroffer? Again, the day 4. What happens on day 4? Expired offer. The seller says, okay, here's my counteroffer. In the SCO, the seller counteroffer, and then also in the buyer counteroffer, there will be sections now for the parties to confirm that the late acceptance is still good, that the late acceptance is still sufficient for everyone. You'll have basically one more signature in there if you have a late one, just to double check your boxes, cover your rears, and make sure that everyone has agreed to everything here despite the expiration of the offer, seller counteroffer, buyer counteroffer, wherever you are in the process, there will be these boxes and these signature boxes for you to use to confirm all this. All right, you're into the transaction now. You're doing the disclosures. You are moving along, and as you may or may not know, you have 2 main personalized disclosures for a property. Okay, you have the TDS and the SPQ. The TDS for a long time has held the statutorily required disclosures in there. And actually, if you look at the Civil Code too, much of the layout and the box of it is right there in the statute. So CAR doesn't usually like to change the TDS if they can help it, because part of it, again, is in the statute, and part of it, let's just keep this TDS set for as long as we can. The document that we use to change with all the updates and everything that comes out month after month by the California legislature is now the SPQ. So you will probably see the SPQ changing every forms release, June and December, because there's always a new disclosure idea that they come up with. So the SPQ has a few new additions here. I'm not going to go through in much detail because they're a little complicated and may not be applicable to your transaction. Make sure that you read the new SPQ carefully, the one released in December, and you check out the new sections that are in there. So you have a new section on the wood balcony and stairs. Wood balcony and stairs. If the balcony sticks out from the structure, if it's more than 6 feet high, if it's built out of wood or wood-based products, you have some additional disclosure requirements to read and fill out in the SPQ there. And then I saw this one. It was kind of funny. I don't know if we have much of this around here. I've done some up in Paso Robles. It's way more important up there. But domestic water storage tank assistance. Apparently, there's some programs that help assist with domestic water tanks. I don't know. It was in there. You can check it out. And then remember your flipper disclosures. This was, we talked about this last time. It's now firmly in place. It's written into the SPQ. There's kind of a format you follow where if you check yes, then you have to go down to this box and answer this question and make sure you provide this thing. The flipper disclosures, remember, less than 18-month turnover. You have to disclose any room additions or alterations. You have to provide a list of improvements, contractors, permits, and a number of other things there. You'll see that in the SPQ and encourage your seller to check that out. That's it for forms. That's not all the forms that have changed. So if you have any specific forms that you use, make sure you look at the forms release, get the red line. It's right there on the CAR website. You can see the 30 or so revised forms that they did. Question?
When they say wood balconies, I mean, they get all kinds of materials that look like wood. How do we know? We assume everything's a wood balcony or what?
What do you do about the, I don't know what it's made out of type balcony? I would probably say defer to your HOA. If it's HOA controlled and maintained, ask for HOA. What have they done about it? But usually it's going to be a contractor, architect, or engineer who's going to make the determination about whether the balcony meets the requirements of this law and then has further investigation requirements after that. It's not up to us to do that. We can, just like almost all disclosures, you can call it out. You can tell your seller or your buyer, hey, that looks like wood. In the SPQ, there's a little bit of language to help identify that. Just give them the information and let them decide what to do. And there are companies out there, they're all inundated because this law is massive, but there are companies out there specific to the balcony inspection world. Question?
Currently, I have 2 escrows with 2 issues with the wood balcony inspection. So one escrow, the HOA is in complete denial, stating that balconies are responsibility of the homeowners. We are not going to do anything. And I sent the form to them. I said that although the maintenance and repairs are the owner's balcony, but based on this form, HOA needs to provide us with an inspection to tell us what's the situation. Do we need to perform any repairs or not? Mm-hmm. And they said that, oh, we were not aware of it. We are going to bring it up to the board, and we are in the middle of escrow, and I have no idea what I need to do.
Yeah.
Second one, the HOA had done the inspections, but they're not providing us with the report, stating that we are not obligated to give you any inspection report. And when we sent the questionnaire for the lender, one of the questions was, is there any deferred maintenance? Mm-hmm. And they said that unknown. So we have no idea if the balcony above the unit that I'm selling is safe or not. Yeah. And
so a lot of questions, some specific scenarios about the wood balconies in HOAs or other places. I'll answer your specific questions privately later. We'll do that. But I would say the right thing, she's doing the right thing. She is following up with the HOA, showing them their obligations pursuant to the new laws. There is I think there's two handouts that can be provided from the CAR website that I've seen as well. And when you don't have an HOA following the law, what do? You're probably going to have to work up the chain of command to inform them and remind them of their obligations. Again, a buyer can buy in a community that is not following the law. A buyer can buy in a community with deferred maintenance and balconies that are ready to fall over. All you are doing is providing the buyer with the information that the buyer needs to make the buyer's own decision. So just keep providing them that information in writing. Remember, it didn't happen if it's not in writing. Provide it to them in writing, and we'll talk later. And the lender might put a hard stop on it, and you've done all that you can, and that's the unfortunate. Let me take one more question, then we'll go to the laws section.
Well, Well, the other problem to that is the assessments that are going to be incurred by the associations where they find out that they're not well capitalized.
Yes.
To pay for this.
The assessments are a pain. There's a form for that. I think it's called the notice. What is it called? It's like there's a disclosure about potential assessments buried deep in the CAR web forms library as well that you can pass on. It's a big problem. What?
It's about what?
About assessments or special assessments. There's a form. There's a zip forms form I've seen before. All right, let's move on to new laws. How many laws do you think were signed by Governor Newsom last year? Throw something out. 500? Zero. Yeah. It's somewhere between somewhere around 800 and 900. I think last year was actually 1,000. So we've gone down a little bit. 800 bills. There's at least, by my quick count, at least 60 laws signed last year that affect real estate. We're only discussing a few of them. I just tell you that because be aware that there's plenty of laws that we can't discuss that affect real estate and also affect us living here. So before we get to the actual laws, though, the fires, the terrible fires in LA and Ventura County have affected so much. And the power of the governor to issue executive orders, we're not talking presidential executive orders, we're talking governor executive orders here that have been issued, are far-reaching and impactful on real estate, even here in Orange County. So you might have heard about the anti-price gouging after the declared emergencies in LA County. Once an emergency is declared, the anti-price gouging statute in the penal code kicks in and prohibits all kinds of pricing increases, gouging, including with regard to rental property, with regard to rental real estate. The California DOJ has sent over 600 warning letters to people that are being accused of or that circumstances indicate they might be price gouging with regard to rental real estate. There are at least two issues I read of California real estate agents who have been prosecuted recently for price gouging fire victims. And in each of the instances, basically, before the fire occurred, they had a rental up for X. After the fire occurred, after the demand increased substantially for that rental housing, they raised the offered rental rate by 38 and over 50%.
Oh my God.
And the DOJ is, again, the California DOJ is kind of indicating that not only is it egregious in the amounts, but these are licensed California real estate agents who should know better. So I'm telling you now, as a licensed California real estate agent, do not be engaged in price gouging right now. There are some exceptions. I wouldn't recommend them right now. Stick to the maximum of 10% increase for the rental rate on any rental housing in any county of Southern California. That's the safe conservative thing to do right now. So the anti-price gouging, do these laws apply to the OC from the LA fires? Well, my first flush reaction before I even looked at this was, no, those are LA fires. That's an LA emergency. Well, digging deeper, and it's not exactly right there in the law, but digging deeper into some of the enforcement that has been done by the California Attorney General and the DOJ, they came out and said, oh no, we think anti-price gouging applies to any counties that are seeing increased demand because of the fires in LA County. Which started to make sense when I thought about it in some ways, right? You might have people coming down from Pacific Palisades that want a similar type home, perhaps in Newport or in Laguna. So it started to make sense. You have people maybe in Pasadena who were moving down the 605 perhaps to other areas. So it made sense. Then I was thinking, do these, there was a time where do these anti-price gouging rules apply to leases of any length? There was a time, and the statute in some ways said, no, these only applied to rentals of 12 months or less. Well, the governor didn't like this. The DOJ didn't like this, especially given the fires, the terrible fires. And there was a new executive order that was issued, about a week ago, February 4, effective March 8, that says gouging is for all leases. No 13-month exception to this rule. Any leases of any length, this is going to be applicable, and it's going to have that 10% limit on it. And then built into that executive order, there was a little carrot that he held out. Again, we're talking high-end homes, especially in Pacific Palisades. There's an exception for SFRs, 4+ beds, that were not previously rented in certain LA County areas affected by the fire. If you have anyone in that area whose home survived and they're trying to rent it out at doubling the rental rate, and they have more than 4 bedrooms, let's talk later, and we could think about that a little bit more. But for the most part, anti-gouging is going to apply across the board, 10%. So stick to those. Now, I've said 10% a few times because we've been talking about anti-price gouging. But y'all might remember 5 years ago, right before COVID hit, we had something called the TPA, the Tenant Protection Act, which also kicked in, which is statewide rent control. Statewide rent control with express eviction controls on it, express rental and rent rate controls on it that applies to all properties in California unless it has an exception. So the TPA this year has a limit that's built into it based on inflation and some other factors, but the TPA this year limits rent increases to 8.9% in LA and Orange County and 9.3% in Riverside and San Bernardino. The big exception that I'm sure you're all familiar with, the big exception to the TPA are SFRs owned by individuals, or at least not by corporations, LLCs, partnerships. An SFR where you've provided the notice of exception to your tenant, or properties built less than 15 years ago. Those two are the main property types that are exempt from the TPA. The rent control limits on them, the rent control limits that are displayed here, and the eviction controls as well that go with the TPA. You might have also heard in the aftermath of the fires that there were people swooping in there to buy up the property, or at least to make offers on the properties, to make what some consider to be lowball offers on the properties. Well, the governor and the executive got wind of this, and they issued Executive Order N725 that protects property owners in fire-impacted areas from predatory real estate speculators by prohibiting unsolicited offers to purchase or acquire any interest in real estate for an amount less than the fair market value of the property as of January 6, 2025. This only applies in certain affected zip codes of LA County and a little part of Ventura County. If this applies to you, happy to give you those zip codes so you can check that out if that would apply to anyone. But this does not prohibit voluntary selling. How they're making the distinction between predatory purchasing and voluntary selling, I don't know yet, but this is just something to be aware of that is a good protection for those fire victims. ADUs. ADUs continue to be a very favored structure type in California. There is something called ADU amnesty that is now built into the law, and it was expanded this last year. ADU amnesty applies to unpermitted ADUs and junior ADUs built before 2020. And this law requires cities and counties to provide a clear process for obtaining permits for unpermitted ADUs. So no more across the board, no more putting in onerous regulations for unpermitted ADUs. If it was built before 2020, there's supposed to be a streamlined process for the county or the city to lead to a permitted ADU. And also generally prohibiting impact fees. If you're not familiar with impact fees, those can be tens of thousands of dollars charged by the county or the city for the building of certain structures. The buyer rep agreement, which we talked about briefly, again, this is now in statute, so even more than what was required by the settlement. The buyer rep agreement is required as soon as practicable. That's what the statutory language says, but no later than execution of offer to purchase. This applies to almost all types of property. So that's commercial, that's land, that's industrial, warehouse, residential. This applies to those except for leases. The statute does not apply to leases. And this is limited to 3 months. Limited 3 months with an exception there for partnership, corporation, or LLC. Remember, there's no automatic renewals. You cannot build into your BRVC that it automatically renews itself. Every 3 months, you need to be having the conversation with your buyer to renew the BRBC if that's desired by both sides. The reason you want to be very careful and very precise with this, don't choose 3.5 months. Don't choose 3 months and a week. 3 months or less is because any violation of this law renders your BRBC agreement void and unenforceable. You cannot enforce a buyer representation agreement that violates this law. You will be out of luck and working for free if you try to enforce it. Best practice and required as a realtor, have a signed BRBC before showing. And from what I hear, this will soon be required by the DRE as well. You need to have it before showing. Most of you are probably realtors here, members of CAR, NAR, so this is a requirement as part of the settlement. But if not, you will probably soon be required as a DRE regulation to have it. If you have those buyers who say, no way, no how, I'm signing your, what are we up to now, 15 pages for the BRBC and all the things they have to sign. There is a limited form, I think it was 3 pages when I looked at it, the property showing and representation agreement. An alternative, if they won't sign the full agreement, usually that PSRA is limited to 3 properties. So that would be your very limited property pool. Landlord-tenant, I'm not going to spend a lot of time on this, but man, there's a lot of new laws in landlord-tenant. It is getting a full-time job just to keep track of the laws and how to do it. Don't do part-time property management. It is, if you are a part-time property manager, good luck. It is getting so difficult. Let me just highlight, this is coming, although as a best practice, I would recommend you start this now. We all have these handy-dandy cameras in our pockets, and the legislature wants us to use them with regard to rentals. So move in and move out photos and cleaning photos will very soon be required for any kind of security deposit deductions. There's an April 1 date and I believe it's a June or July 1 date. I'm recommending everyone starts this now. Take photos of the place upon move-in, upon move-out, and photos of any cleaning or repairs that are done that you intend to deduct from the security deposit. Also, no more automatic deductions, no more automatic $300 carpet cleaning upon move-out, no more automatic anything. The only deductions that can be made from the security deposit are for non-normal wear and tear, repairs, cleaning to bring back to the state that it was in when it was rented, missed rental payments, a few other things in there, but no automatic deductions from the security deposit anymore. What else? Unlawful detainer eviction response time has now changed. It was previously, a while ago, it was 5 calendar days, then it changed to 5 business days. Now it's going to be 10 business days. So 10 business days, you're looking about roughly 2 weeks for a response from your tenant once they are served with the eviction papers. There was a little carrot held out to landlords, which was there's something called a demur. It's a form of a motion to dismiss. So they shortened that timeline to give a little carrot to the landlords, but it's going to take a little bit longer than it already does to evict if that's what you have to go through. Again, there's a lot of laws. I only touched on a few of them, but There's a number of them. Check out CAR has a great write-up of it. There was probably 20 in that list. There's other lists you can get that show you the new laws that are. One question?
You said no more management deductions in other events for any repairs and such, but then you said for normal wear and tear. How are you?
Yeah. You cannot deduct for normal wear and tear.
Okay. Oh, okay, got it.
Whatever that means is up to the judge. Okay, but normal wear and tear you cannot deduct for. Question?
You charge like $250 refundable cleaning deposit. It has to be part of the first month's dollar amount.
There's
Is that legal?
There's really no such thing now as a refundable or non-refundable anything. It is a security deposit that is used for repairs, for cleaning, for missed rent. I would stop designating separate funds or amounts for X or Y. Just security deposit. The pets. Let's not go down that path yet right now, because then we're going to talk emotional and service animals, and we'll lead to some other things. All right, let me keep going. We can talk later. New cases. Let me just bring a few of these to your attention. Burnett-Sitzer was not all there is. I mean, there's so much going on. Federal and state litigation. There's copycat lawsuits of the Burnett-Sitzer lawsuit. There are issues of buyer claims not yet resolved. Remember, the Sitzer case only had to do with seller claims of being duped and anti-competitive. The buyer claims are still out there, still being litigated. There's at least 20 cases around the nation of similar claims as Sitzer-Burnett, but on the buyer side. So I was looking at them today, mostly in federal courts. There was somebody who was trying to get them all into one court. They were trying to get it to the Missouri court where the Sitzer-Burnett case happened. The multi-district litigation judicial panel said no, they're all going to stay where they are right now. There's at least one case pending in Northern California right now that could have impact on California practice, so stay tuned. It's nowhere near over yet. You might have remembered a little ways back, there was the NAR versus United States case. What happened in this was the Department of Justice for the United States was investigating NAR, certain practices. The parties reached a settlement agreement between NAR and the United States. In July 2021, the DOJ said, we're going to reopen that investigation that we closed, and we don't think that settlement agreement covered it, and we are going to issue a new subpoena to NAR as part of our investigation. NAR said, no, we already resolved all this. We have a settlement agreement. Abide by the settlement agreement. So NAR took it up to the district court. The judge agreed with NAR that the subpoena had violated the settlement agreement and the issues were already covered in that settlement agreement, and the DOJ should close its books. Well, the DOJ didn't like what the district judge said, so they took it up to the D.C. Circuit Court of Appeals, and the D.C. Circuit Court of Appeals reversed the district court and said, no, the DOJ can reopen its investigation. We think that that's fine. The settlement agreement didn't cover it. So then NAR said, okay, we're going to the Supreme Court, and the Supreme Court said, we don't want to hear it. As is their right. I mean, they declined to hear the appeal. They said, no, we're not getting involved in this right now. Well, what's happened between that DOJ investigation and today is an election. And whether the election changes and whether President Trump has new instructions for the DOJ in terms of their investigation of NAR and NAR's practices remains to be seen. My personal prediction is I'm going to go out on a limb and say that those investigations are going to be closed for the next 4 years at least. And there's going to be the settlement agreement will be abided by for now. So this book is probably closed for now, but it remains to be seen. One more. Landlord-tenant law. Because all right, you have a property. Your seller wants to list the property, but there's a tenant there. You don't want to list the property with the tenant in there because that makes it difficult. So you are hoping that the tenant will leave peacefully and will comply. What do? So in this case, 30-day notice to terminate tenancy was issued. The landlord, though, accepted, deposited, and didn't refund rent from the tenant one time. And then another time, the landlord accepted, deposited, and didn't refund rent again, as well as CAM charges, common area maintenance charges, from the tenant. But the landlord said, I'm not consenting to you being here, I'm just taking your rent. The landlord took that argument to the court and lost. This opinion was issued a couple weeks ago, and the Court of Appeals said, no. When you took that rent from the tenant, you were renewing their lease, at least for that period of time, generally 30 days. So if your seller does not want that tenant there anymore, tell your landlord not to accept any rent. Seems simple, right?
What's not automatic?
Don't accept rent if you want that tenant out. If you've done the notice to terminate tenancy, don't accept rent anymore from that tenant. Refund the rent if they automatically put it in their bank account. Otherwise, you might have your tenant renewed again and again, according to this recent Court of Appeal opinion. All right, that's it. There's my contact info. Website is zutellaw.com if you want to make a consultation appointment. Feel free. We offer those complimentary consultations, and happy to talk to each one of you. Thank you, Generations Escrow.